Hi, my name is Alex Dolphin and welcome back to another episode of Ex Ante. Today we're going to discuss the case of Ernst v. Conditt. This case was heard in the Tennessee State Court of Appeals in the year of 1960. Let's go ahead and jump into the facts of the case. So Ernst is the plaintiff. They're a landlord. They own a large piece of property. And they leased this property to a gentleman by the name of Mr. Rogers. Mr. Rogers was obviously a fun guy because he wanted to use the property to build a go-kart course. So he built the go-kart course, put the paving down, put the lights up, and began operating this business for some time. Him and the Ernsts were in good relationship with one another. He paid his rent. Everything was hunky-dory. At a certain point in time, Mr. Rogers, I think, is an adventurous guy. He got tired of operating this go-kart business, so he begins looking for a buyer of the go-kart business. He does find a buyer. It's Mr. Conditt, who is our named defendant in this case. And Mr. Conditt buys it, but he wants Mr. Rogers to go back to the Ernsts, to go back to landlords and say, hey, can you help me renegotiate this lease so it's a little bit longer? Mr. Conditt wants the lease to be longer so that if he's going to buy this business, he at least knows that he can operate it for some time before the landlords decide, hey, lease is up, I want you off the property. So Mr. Rogers does do that. He goes back to the Ernsts and they renegotiate the lease. And this lease, it says in the lease agreement that Mr. Rogers is now allowed to sublet this property out to Mr. Conditt. So Mr. Conditt begins operating. He uses this business for some time, doesn't pay his bills, of course, which is how we end up in court. And the Ernsts, file a judgment and they say, hey, or they file a complaint and they say, hey, we want to get paid for this rent that was owed to us by Mr. Conditt. So they go to a chancellor. The chancellor says, yep, sounds good to us. Mr. Conditt owes you the rent. Well, Mr. Conditt didn't show up to the hearing with the chancellor, but he gets wind of this judgment and he gets really frustrated. So he decides he's going to appeal this to the Tennessee State Court of Appeals. And Mr. Conditt says that he has no obligation to pay the landlord's rent because he doesn't have any privity with them. He's not privy to the contract because all that his involvement is just a sublease from Mr. Rogers. And just because, so if it's a sublease, the only one that he can be responsible to is Mr. Rogers. Mr. Rogers can bring an action. But if the Ernsts want to get paid, they got to bring an action against Mr. Rogers. So that's the argument that Mr. Conditt develops. Ultimately, the court has the task of deciding, was this new lease agreement a lease assignment or a sublease? That's important because if it's a sublease, then there's no privity and Mr. Conditt, the landlords, the Ernsts, can't recover against Mr. Conditt. If there is an assignment of the lease, then the landlords can recover from Mr. Conditt. That's what the chancellor ruled, and that's ultimately what the court is going to rule as well, that this was an assignment. This ruling is a little bit counterintuitive because the lease agreement says that there was a sublease. This was to be a sublease, and it's written there. And so the court kind of has to grapple with that. And the court says that the common law rule now isn't to look to the exact language in the lease agreement, rather it's to look to the intent. And if an individual in what could be a sublease or an assignment of a lease is going to take over that lease until the end of the term, then naturally that person is going to take on an assignment of the lease rather than a sublease. So the court points to two factors: one, that Mr. Conditt was taking over the lease till the end of the term, and then two, that common law states that it allows the courts to look to the intentions of the two parties when they're forming the lease agreement rather than the actual words of the lease agreement. So that's the case. It rules in favor of the plaintiffs. They're allowed to recover these past due rent payments and the cost of having to remove a go-kart track from their property from Mr. Conditt. So let's just jump into a little ex-ante discussion about this case. I think that this one kind of is topsy-turvy because the lease agreement specifically says that Mr. Rogers is subletting this property to Mr. Conditt. So it's pretty clear that it's a sublease, and the court decides that they're going to throw away the actual writing of the lease agreement and they're going to impose their own rules on it because they believe that they can discern the intentions of the two parties better than the two parties can discern their own intentions, if that makes sense. When this agreement was written, the impetus is probably upon the Ernsts to understand what a sublease is and that they can't recover from someone who subleases. And if they don't like that, then they should have just said this was an assignment of the lease in the new lease agreement rather than a sublease. So the court, it takes kind of an ex post perspective in that it's saying that, we're just going to look to the intent of the grantors, which basically means we're just going to try and do justice the best way we can. But that's not very consistent, and that's not very predictable for people to just like think, well, how is the court going to discern my intention in the future? And how can I make sure that my intention is known in this moment? Even if you write it down, the court isn't going to validate that intention as legitimate, as in the sublet clause, the sublease clause in this lease agreement. So that's the ex ante implication I wanted to discuss. I hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button, and I hope you have a nice rest of your day. Bye-bye.